I'm Bill Froehlich. I lead the Mediation Clinic with my colleague Sarah Cole here at the Moritz College of Law. And students in the Mediation Clinic this semester have designed this session, or principally designed this session, celebrating the 25th anniversary of the Uniform Mediation Act. So I am delighted to turn it over to Priya to kick us off.
Hi, my name's Priya. I'm a 2L and I'm a student in Professor Froehlich's mediation clinic this semester. Very excited to be joining you all here today. First, I'm just going to introduce our amazing scholars that we have speaking here today. First is Professor Nancy Rogers, who is a Dean and Professor of Law Emerita here at the College of Law, former Ohio Attorney General, former Dean of the Law School, and also a reporter on the Uniform Mediation Act. Next, we have Professor Ellen Deason, who is a professor of law emerita here at the law school, who is specifically integral in drafting some of the 2003 amendments, and it's also acknowledged in the reporter's notes of the UMA. Professor Sarah Cole, who is the Michael E. Moritz Chair in Alternative Dispute Resolution, also acknowledged in the reporter's notes. And for any of you who are joining after our Schwartz lecture this morning, our amazing lecturer, Professor Michael Moffitt, who delivered amazing presentation on the policy objectives of mediation, who serves as the Philip H. Knight Chair, professor and faculty fellow many roles at the Clark Honors College. Thank you all so much for being here, and I'm going to pass it back over to Professor Froehlich.
Thanks, Priya. Oh, this is so exciting to have this wonderful group gathered here together. And so let's get to it. Let's hear from them because that's why we're all here. By the way, if you have questions, just hit me up in the chat. We will definitely get to them today. I know it's not a large group on Zoom, so we will get to all your questions. We will make space for discussion. But what we're going to do today is hear from Nancy, followed by Ellen, Sarah, and Professor Moffitt. And then they're going to engage in discussion, and then we'll take Q&A. So we're going to turn it over first to Professor Rogers to hear a little bit about the background of the Uniform Mediation Act, as of course she was the reporter for this project. So Professor Rogers, you tell a story that I've heard a couple times before, where Dean Meeks, back in the 80s, asked you to teach a class that involved mediation. And you say, and I watched a recording of this morning, that was recorded by the Supreme Court of Ohio. You say, at the time I had to look up the word mediation in the dictionary. We've come a long way, haven't we? My goodness. So I also understand that Frank Sander, you worked with Frank Sander as well. You called Josh Stolberg and said, what do I do? What do I do to teach mediation in this class? And then years later, you and Frank Sander were thinking about, should there be a uniform law on mediation? And I understand that Professor Sander, formerly at Harvard, late Professor Sander, asked the Uniform Law Commission if they would start a Uniform Mediation Act process. And the Uniform Law Commission said no at the time. So you and Professor Sander, I assume, initiated a project with the ABA, a model statute project, as I understand it. And I'd love to know what was taking place in the mediation field on the subject of uniformity, and that was a precursor to the development of the UMA. What led you and Professor Sander, to propose to the Uniform Law Commission that the UMA be developed? What were the tensions that you all were thinking about?
Well, I think, I will say, as knowing you would ask that question, that it's hard to sort out 25 years later. I know that what was my impetus initially changed as I learned from my colleagues, and I changed my mind considerably. But as I best remember it, Bill, I was working on the treatise that Sarah and I update each year, and I was reading the statutes and thought, I think that now that people have tried 1,000 things, it's time to take a look and have some thoughtful people think about what might be the best approach in law. So it was an ambiguous feeling. And when we first approached the ABA, they said that a part of the reason they hadn't undertaken it, they too had the same feeling, was in the council, was that they didn't have the money to hire scholars to do the research that would be necessary to really look across. And so I talked to my colleagues, and they here at Ohio State, at Harvard and Missouri, and all of them were quite willing to donate their time essentially to provide that kind of background thinking. So what really threw us, we began, and once we began with the APA to write the Model Act, which we hoped would solicit more comments about what ought to be in the law and what ought not to be. We didn't think of it as uniform, was that we began finding what it would take to get the ABA to approve a model law if we came up with that. And in thinking that through, we decided to pick co-chairs and encourage a drafting committee that would result in it being trusted at the time that the ABA decided whether to pass it. And so we asked Chief Justice Moyer from the Ohio Supreme Court, Chief Justice, to be one of those co-chairs, and a former president of the ABA who would know how to gain that kind of confidence in the work to be the co-chair, and managed to find also funding for the project going forward. And we're about to meet when we discovered that the president of the Uniform Law Commission, who was a mediator, had mediated in South Dakota and been subpoenaed to testify in Nebraska. South Dakota had a privilege. Nebraska didn't recognize the South Dakota privilege. And so he reconvenes the group within the Uniform Commission who decide when it's ripe to consider a particular law, and they voted to do it. And it appointed a chair already. And so Chief Justice Moyer and Roberta Cooper Ramo called the person appointed and said, let's talk. Let's have a conference call. We'll have Nancy on and let's talk about it. He said, well, the way the ABA and the Uniform Commission have worked together for decades is we draft a law, we present it to the ABA endorses it or not, and then it goes out to the states. And so that's the way we operate. And Roberta Cooper Ramo said, well, we're mediators. Perhaps we can think of a better way to operate going forward. And so they talked it through and they came up with a formula to present to both the ABA and the Uniform Commission. And that would be that they would separately appoint committees to draft, but they would do it in consultation with each other so that they had the broadest possible representation and would get good people like Elizabeth Kent on it. Then they would meet at the same time and they would use the same reporter initially. Later, I think they separate, and they would use the faculty group as their researchers. And we would go back to the foundation that had funded the ABA initiative and ask if they would also fund the Uniform Commission initiative. And both sides agreed to that approach, and it worked very well, I would say, in terms of process. It was a group of people who were remarkable, and the votes were never ABA versus Uniform Commission. It was a struggle. It was sometimes a very adversarial process of the discussion, but never broke that way.
Amazing. I thought I knew just about the whole story, but the illustration of the Uniform Law Commissioner, the chair of the Uniform Law Commission, who had the mediation in South Dakota, but was subpoenaed in Nebraska, your home state? No, Kansas is your home state. Nebraska is your home state. And that's what inspired the Uniform Law Commission to get on board. What a really interesting and nice tidbit. Thank you so much for sharing that illustration. I also, in preparation, found this quote about Thomas Moyer from Frank Sander. And I just wanted to share it with the group because I know that many on this call, many watching this recording and here on the stage have had such a fond relationship or fond memories of Frank Sander. Frank Sander wrote on Thomas Moyer, the late Chief Justice here in Ohio, in a message to the dispute resolution community titled Some Concluding Thoughts. It was published in the Ohio State Journal on Dispute Resolution in 2002. We must also, as the dispute resolution community, quote, continue to find and enlist influential movers and shakers like Chief Justice Thomas Moyer. to keep doing the work, to keep expanding the work in of dispute resolution in the court context and beyond. And so I'm glad, I appreciate you bringing that up, Professor Rogers. I want to turn it over to Priya, who has a follow-up question for you.
Yeah, we've already touched on confidentiality a little bit, but why did the drafters elect to address confidentiality through privilege and not through some other vehicle, such as strict confidentiality or mediator capacity?
Well, certainly all three of those models were discussed throughout. I think the capacity one, the mediator's doesn't have the capacity to be a witness, came mostly from the collective bargaining field. And in fact, they were so happy with that model because they were not worried so much about what they said being used as evidence in some way. They were worried about the mediator taking sides. And so they, at the beginning, said to us, if you draft for the context in which people really, what the parties really care about is the use of their statements in some future litigation, we want to be excluded from the act. So one of the first things we did was to say yes. If you say it's been working for decades, the law is clear, and it is, because it's mostly federal law, fairly consistent across the country, we will exclude that from it. But the capacity that didn't solve the problem that was the worry of many of the parties. The next model, the confidentiality model, let me just say that the first of the problems is that no one quite knew what that meant. So it may come from privilege statutes like the attorney-client privilege that says that relationship is confidential and that the client has a privilege and then it follows after that. And the confidential part is not interpreted that the client can't talk about it outside if the client wants to. It more is a kind of descriptive or limiting term so that if the client does talk a lot about what was said with the lawyer, it might waive the privilege. But what people were talking about in the mediation context was very different. They wanted somehow everybody involved to be prohibited from talking more broadly. And saying it's confidential in a statute, you really didn't know what the court would do. So it was unclear what the court would do. And telling people that they couldn't talk about it might work in some contexts, but it seemed terribly unjust in others. Some people, like a small claims court, would not expect that they were going to be liable or in some way had some problem if they told their friends what had happened, if they needed to unload. In family cases, if they felt they had to tell their children, or maybe they have children but needed to tell a friend, it seemed quite wrong to tell them not to do it. And that began all the problems. But that request followed us, Priya, throughout the drafting process, because there were statutes that simply said mediation was confidential, and people thought we should say it too. So at one point, we drafted Richard Rubin, who worked with me and as a reporter. We drafted a confidentiality statute with all of the exceptions that people in the discussion had said would need to be there. And it was horrendous. It was horrendous. We came back and everyone said, this can't be done. This can't be done. So we were able mostly to set it aside, but it was there as a voice always. The privilege had become, for the reasons that we can discuss, it had become the predominant mode for mediation. It was in more recent statutes, the approach that was being used. And in the Uniform Commission, they like to think that their acts are enactable. And one way to make an act enactable is, of course, to do something somewhat similar. So that was a plus for them, but also it fit. It could be shaped in the mediation context to help the parties' expectation be clearly communicated. And it could have exceptions to deal with some of the other policy concerns.
Thank you. Moving the conversation in another direction, what were some of the other challenging questions that the drafters had to answer and address during this process?
Right from the start, we began to realize as the faculty group talked, and it persisted throughout, that there were some really hard choices. And they were always there. This question of, if you make something sort of secret in terms of how the legal proceedings are going to hear about it, what mischief will occur that we would not want to occur, and how can we handle that? You feel like as you do that, you have the responsibility, even if it's only a privilege statute, to think about the worst ways in which that can be abused. But of course, every time, it's the tension Michael spoke about in his wonderful talk. Every time we paid attention to that, we were reducing, in some sense, the sense that everything said would remain there. And so there was always that struggle. And I think that the criminal area was one of the toughest areas to deal in that. At one point, it would be cured by the Constitution, in the sense that if it was the defendant who was not able to get the evidence needed, the court would require it as a matter of due process and right of confrontation. But to have a statute that didn't take that into account and had to be declared to be violative of the Constitution did not seem like a good way to go about it. On the other hand, there were some really fascinating mediation programs that were doing good work in gang areas and in other areas where the admissibility in criminal matters really mattered. And in also commercial matters, it mattered a great deal if you had to avoid all tax liability, all criminal tax liability by being really careful that your client wasn't speaking too candidly. So it was constantly there as a tension. And I think that another area was this area of who holds the privilege. There's no question that it should be held by the parties, that their reasonable expectations should be met. But why would it be held by the mediator? In the attorney-client relationship, the attorney has no right to assert the privilege if the client does not want it asserted. So the justification for that we've heard first is, I don't want to fly all over the country testifying. And in other contexts, privileges being such major things, that was not a justified exception, as the courts, as a matter of common law, created privilege. They said that doesn't do it for us. Inconvenience is sometimes required in the interest of justice. There were some other justifications that were given, the appearance that, having mediators talk all the time will make people believe that there's no privilege, really no confidentiality. There is a sense that once you take sides, people won't believe that mediators are, because it will always fall against one party. You won't believe that they're unbiased. And there were more arguments. Ultimately, I believe that the enactability of the law became a factor, and so the mediator was given a kind of limited privilege. And the way we dealt with that was simply to try to cut it as fine as we could. So it's one of the most complicated areas to read for that reason. There's always a trade-off of complexity and precision, but the mediators gets a certain kind of a hold on the privilege, a certain kind of right. So by narrowing it, that one we did by narrowing. Some we did simply by carving it out. If we thought that it was a strongly felt view, and yet it would affect very few mediations, we sometimes carved it out. So that we did that with the public records exception. Rarely do mediations fall within those laws. When they do, people feel very strongly and differently in different states. In some states, no statute would pass that made an exception to public records, public meeting laws. And in other states, it would not be a problem. And as the enactment has occurred, that's exactly what happened. Some states opted one way, some another. And we thought that there was still a sense of a uniform privilege if we gave that kind of freedom. I think that one of the most troublesome ones was people who had never practiced law and therefore had never been accustomed to the attorney-client privilege. And so they had no sense of how the privilege law would be interpreted. And they wanted us to say things that we knew wouldn't be necessary to say. So for example, they wanted to say that if somebody summarized the communications, that too would fall within the privilege. And yet the law is clear that what you do directly, you can't do indirectly, and the courts will always stop that. So it would have further cumbered the statute to say some of these things. But ultimately, we did say a few things that because of enactability, we said some things that were obvious under the law. And, if I think there was a little sense of silliness in saying them. And also the risk that any time, because courts will say, sometimes it's a matter of interpretation, that the legislature must have meant something by the words and will give it a meaning, that it's a little careless to say that. But one section of the Uniform Mediation Act does just that.
Well, Professor Rogers, we have one more question for you, and then we're going to turn down the panel. Sorry I feel like we've thrown a lot at you so far, but as the reporter, you're the center of that knowledge. And I know that you and Richard Rubin and Chief Justice Moyer and Roberto Ramos were so involved in this process. So I wonder, the UMA has been around for 25 years now. So what did you learn personally or professionally? What did you take away from the Uniform Mediation Act drafting process? And upon reflection, given the modern context of ODR technology and AI now, are there any considerations that we should be thinking about to update or modernize the UMA 25 years later?
Well, certainly it was a process of learning, Bill. I would say, at the very beginning, I thought we could do all the law mediation in about a paragraph. I was constantly learning how wrong I was, and learning about applications that, that the law would affect. Elizabeth Kent told us about various processes in Hawaii that were still being practiced, and we're sort of like mediation. We need to be really careful. And even in the final enactment by the Uniform Commission as a whole, there was an example of by a dean that he was afraid that his conversations with faculty, which were sometimes negotiations, would be deemed mediation, and he would be unable to take the information from that. And because we described mediation so broadly to be as inclusive as we could, and right there on the floor, we had to make a change because it was true that we had done too broadly. So we were learning all the time. I think though that, just what are some of the takeaways? Some are that I think we have improved the law in through that process of hundreds of people being involved in it in some of the states, in the 13 states and the district that have adopted it, but also the exception approach has been adopted in 3 other states in their statutes. And we've noticed, and Sarah will talk more about this, that some courts are adopting the reasoning in interpreting some of the more general statutes in their own. So it feels as though the effort really brought together a lot of thinking, helped people to see more points of view than they had, and resulted in some improved practice. So that feels good. At the very beginning, I don't think in our faculty discussions that we really felt we needed to make it uniform. We wanted to contribute to the improvement of law.
Mm.
And so in that sense, it has. You know, I learned later that it was as important to think, or maybe somewhat important to think about how crossing commercial business crossing national borders also needed some of the same treatment. And again, the complexity of that is always surprising. But I think other than making some wonderful friends in this process, that it there was a collective sense that we did what lawyers should do, what we promised to do when we take our oath, and that's to do our best to contribute to the improvement of law and its administration.
Thank you so much, Nancy. I know we're going to come back to you, and I know you have more to say, but we're going to transition, and this seems like a perfect transition with the mention of international issues to Professor Deason. And we have a few questions for Priya.
Professor Deason, you were very involved in the 2003 amendments in the drafting process of that. Could you both share a little bit about your role in that and also react to some of what Professor Rogers has shared with us today?
Sure, thank you, Priya. I was a substitute reporter, and this was a follow-on. The Uniform Mediation Act had been adopted by the conference in, I believe, 2001. Mm-hmm. And simultaneously, on a parallel track with negotiating the UMA, was a negotiation internationally under the auspices of UNCITRAL, which is the United Nations International Trade, you call it UNCITRAL. And they had negotiated a model law, which was about confidentiality in mediation and has been since adopted in many, many countries. And they do not use a privilege, because a privilege is really a common law mechanism. They use an evidentiary exclusion. But there was a coordination between one of the chairs, Judge Michael Getty, and the chair of this international effort, and they kept in touch, and the whole idea was that the two would be compatible. So it was like the UMA, pretty much focused on confidentiality, but meant to be a national law, not a state law. And we decided, the conference decided to amend the original UMA and add in this. So this was essentially, how are we going to wrap in the broader picture of across borders? And it was very simple in the end, because what we did was essentially say, if it's international and it's commercial, you follow this international model law unless you agree otherwise. And so they had an option to opt out of that, in which case it would not be governing. And it was a great privilege from my perspective to be involved in some of these meetings on doing this. And it has led for me to since then a very strong interest in the international aspects of mediation, and how if you think that there's diversity and lack of uniformity among the United States, the states of the United States, look at all the different countries. So, I have a general reaction. I know that Priya's going to ask me about uniformity, and I'm going to agree with Michael Moffitt that the UMA has not been spectacularly successful at creating uniformity. My theory is that a lot of states already had statutes when the UMA was adopted by the conference, and they didn't want to revisit it. They did not see the point in exercising the energy to replace their statute that was good enough with one from the ULC. And I would say that even among the UMA states, there is variation, not only with things like the public records and various criminal provisions, but there are three main different versions when you look at how they treat internationally. Because some of them, well, I should back up and say that the amendments were put into the 2003 version of the UMA, which is what you'll find online, and what most states are now adopting. But so there are the first group of states that enacted, and they have the original version with nothing international. And I think there are about 6 of them, 6 or 7. Then there's a second group that adopted the version with none of the first group went back and said, oh, we need international, which I think supports my theory that why mess with it if it's not terrible. And there are 6 or 7 in that second group. And then we have more recently the Singapore Convention, which doesn't deal at all with confidentiality, but deals with enforcement of agreements that are reached in mediation. And our one state, which is Georgia, incorporated that into their version of the Uniform Mediation Act. So instead of just saying international for confidentiality, they have essentially adopted the Singapore Convention on enforcing mediated agreements before the United States has. So, in what I think is a wonderful irony. So all that aside, I think that the Uniform Mediation Act makes huge contributions aside from uniformity. And I've been the reporter for another act, and I think that it's fair to say there's always a rigorous multi-step drafting process at the Uniform Law Commission. There's this emphasis on bringing in important stakeholders as observers. And I think you alluded to the participation. The result is quality legislation, and it's based on considered policies, and as you mentioned, designed to be widely acceptable to the states. And that's sort of in the interest of uniformity, get more adoptions. I think the Uniform Mediation Act is a great example of the quality that's possible. I mean, it really sets the standard here. 25 years later, we're still having states adopt it. Connecticut this past fall. So it still has legs. So when they do decide, let's get a new statute, they look to the Uniform Mediation Act. And I think there are a lot of new efforts right now with mediation and family law. And I want to give a shout out to Donna Araz-Naveau, who I believe is on the Zoom, who's a reporter for a study committee at the Uniform Law Commission on whether to draft a Uniform Family Mediation Act. And I think that the renewed focus on this brings it back to mediation in general. And so I envision renewed focus as states get involved with the new Family Act. They may come back to the more general act.
Thank you. Yeah, you definitely answered my question. So I'm going to turn it back over to Professor Froehlich.
Oh, thanks, Priya. So Professor Deason, could you say a little bit more about what the advantages and drawbacks might be? Or could you talk a little bit about what the advantages and drawbacks might be of having a federal mediation privilege that complements the UMA framework? I know you've thought a lot about uniformity with respect to privilege and confidentiality on the state level and the federal level. If you could say more about that.
Well, I'll try to be brief. It's a big topic. I think the first thing you have to think about are the benefits of uniformity for mediation confidentiality. And I think there's, it's sort of, they are consistent with the Uniform Law Commission's general goal of uniformity for all its laws. It supports interstate commerce, right? Companies don't want to have to consider different legal rules in every state where they do business. And this saves transaction costs and reduces litigation. Now, that doesn't mean that you always want uniformity because there are different circumstances in different places. I wouldn't say we want uniform water law between the West Coast and the East Coast. But procedurally, I think procedures are a good place to look for uniformity. Even more important from that for me is a related point that I think companies and individuals highly value predictability. when it comes to the legal landscape. What law are they going to have to deal with? Now, you can have predictability without uniformity, but not in any kind of complicated scheme with a series of choices. In that case, I think uniformity is the easiest way to predictability. The illustration that you gave is a perfect example of why uniformity is important here. So you've got a whole lot of choices. First off, if the lawsuit raises confidentiality issues, what state is it going to be filed in? Not necessarily where the mediation was held. You might not anticipate. It could be anywhere with jurisdiction. Second, will it be filed in state court or federal court? Another uncertainty, another outcome determinative choice in terms of what confidentiality can apply. If it's in federal court, will the federal court use state law? We teach whole courses on that topic. Civil procedure, everyone's favorite part is the Erie Doctrine.
Correct.
And the Erie Doctrine makes this look really, Erie Doctrine looks simple compared to this. Because there's a special rule for deciding when it's privilege, whether it's state or federal. Finally, if it's going to be state law, what state law will the court choose? It's not necessarily the law of the state where the court's sitting. We have a whole course in choice of law. So I think the central question, what are the protections of whatever law gets chosen for confidentiality, is only the last issue, and there's huge variation there that I won't go into. So I think that the outcome of this procedural cascade, I guess you could call it, is that it's really complicated and it's unpredictable. But if the laws are uniform, no one has to worry about the cascade or the contingencies, because then the outcome will be substantially the same enough, no matter what court and what law. So that's the case for uniformity in general. I think there's also a reason that's unique to the setting of mediation and confidentiality. You talked about privilege, you talked about the attorney-client privilege. The purpose of all these privileges that we have is to encourage communication. So the lawyer can't do her job well if the client doesn't share her whole story. And the lawyer-client privilege makes openness more likely because it protects those communications from disclosure, right? That's just basic privilege law that unless you've had evidence, you don't understand, right? And it's so in mediation, sharing information with the counterparty, or at least with the mediator, is seen as a way to open the door to trade-offs that can lead to agreement or to a better agreement. And so the information communication is, as with all these other privileges, really important. Now, I think it's even more important in mediation because you're not dealing with two people, you're dealing with three. You have a triangle. When it's the lawyer and client, or the priest and the penitent, the doctor and the patient, you think of them, they're on the same team. Mm-hmm. They're going to be if not completely, in agreement, not working to undermine each other. In contrast, in mediation, you've got a counterparty who can be opposed to your interest. In fact, they can be your opponent in an existing lawsuit, or even if there's no lawsuit yet, they can become litigants if there's no agreement, or there's a settlement and they disagree about enforcing it. And there we are again with opposing parties. And so there's every reason not to trust the other party. And I think that this posture then raises the stakes for disclosures, and that a participant in mediation is less likely to be forthcoming if they fear their statement can be used against them. So they need to know, and they need to know upfront at the beginning of the mediation if their communication is going to be protected. And to me, that means predictability to at least some extent. So when I think of it is in the mediation setting, that this legal mechanism of privilege can, at least to some extent, operate as a substitution for trust. The trust that what you say can't be used against you. I'm a little bit contradicting myself because I know in practice we don't list all those exceptions at the beginning of a mediation, and so there isn't full and complete predictability. But I think that the existence of the privilege in general and some signal that you have to be careful and trust your attorney can open doors in ways that is unnecessary even with other privileges, and particularly important here. So that's my pitch for uniformity. Oh, and I forgot about the federal courts, but that's part of that cascade, right? So for all the reasons that we worry about the difference between what would happen in one of the Dakotas and in Nebraska, we have even more concern about what happens if we're in federal court and looking to state law, and then which state law do they choose, or do they choose federal law? And it's not a perfect terminology, but I think in terms of horizontal between the states uniformity, and that there would be additional benefits if we had vertical between the states and the federal court systems. So, thank you.
Thank you, Professor Deason. I appreciate that pitch. Priya, I think we're going to turn to Professor Cole now for some of her reactions. So if you want to go ahead.
Yeah, you were also very involved in the drafting of the UMA. Can you provide any additional context to what Professor Rogers and Professor Deason have already spoken about, and any general reactions to their comments?
Absolutely. Well, first of all, I'm very honored to share this opportunity with Professor Deason and Professor Rogers and Professor Moffitt, three scholars who I greatly admire in this field. And every time I listen to you talk, Ellen, I just agree with you. So but I always feel I've developed greater insight into the whole process.
Thank you.
And Nancy, I can't tell you, how honored I was to participate in the academic advisory faculty for the UMA. I don't know if you remember, but you invited me even before. I think I'd been offered the opportunity to join the faculty at Ohio State and accepted it, but I hadn't even arrived in Ohio, and you invited me to, I think it was Dallas, to work with these luminaries in the field of alternative dispute resolution. And so I think I was pretty quiet during the discussions, because at that point I was learning a lot about mediation. I had been teaching the survey dispute resolution course, but certainly I never mediated a case at that point. And so I remember, certain conversations very distinctly. And I remember the community mediation folks talking so much about how important confidentiality or privilege was to them because of the need for candor, even if it meant that some of them would reveal that they'd committed crimes in the course of the mediation, that they would rather have this absolute privilege despite the constitutional. I mean, I don't think that was important to them. I think they thought, these issues are just so critical to us. And they were just, I think what you said, Ellen, too, about the comprehensive nature of the discussions, that there were iterations of the drafts and there were conversations from so many different groups. And of course, in the end, you have a compromise document, but it's hard to imagine that most voices didn't feel adequately represented or heard in the process, because we had such extensive discussions. And I remember in particular a discussion about conduct. I don't know if you remember this, Nancy, where somebody talked about, if you wore a hat that had some awful statement on it, would that be considered a statement? And I think we ended up having that in the notes, but it was, is that communication if it's not speech? And many things where we were just drilling down into these. Do you remember?
I do remember, and I do remember learning from the uniform commissioners that explaining it in the notes was a good way to deal with people who weren't lawyers, because they felt you had to say it in the law. But if you said it in the notes, it somehow made them feel better.
And I would say my other two observations, and actually sort of almost have the question of, I love the fact that there is a section that allows a party to bring a support person into the mediation. Although I also noticed, just reviewing the different states, that some states didn't adopt that. and then the whole idea that a mediator must act reasonably in making decisions about disclosure, which really mirrors what happens in tort law with regard to disclosures. And I also remember Judge Getty telling us anytime we strayed from confidentiality, that if we wanted to put that into some kind of thing, it had to be a model act. It wasn't going to go into the Uniform Act. But how did we get those couple of provisions that weren't related to confidentiality into the final statute? I don't remember. I don't know. And I remember we never got enforceability of mediated settlement agreements in.
We didn't think, I think the standard we were using and kind of agreed to, although, there were lots of remembrances and it was 26 years ago. But I think that the standard was, what is it that the privilege could make worse? And if you were there and you couldn't afford a lawyer and you didn't have a support person, and on the other side was the company, it would be a tough situation for you, particularly since it was a secret in some ways. So some of those things we thought had to follow. Mm-hmm. Enforceability didn't have to follow and would be a whole new drafting process.
Interesting.
So, but we thought Ellen could handle that.
Exactly. Well, it is funny because I think it's so important to have a support person, but as someone who's watched a lot of small claims court mediation, sometimes the support person is the impediment to the outcome. But I think on balance, it was absolutely the right call. It's just funny how that's
it is funny. And it only really is a problem in mandatory mediation because of its voluntary mediation. The mediator can say, I don't volunteer to do this mediation. If the support person's going to be here, find another mediator. And I think that piece we didn't convey adequately, but that could still happen.
That was an amazing conversation to listen in on. Professor Cole, I know some of your scholarship, you've looked into some of the case law that's developed that's connected to the Uniform Mediation Act. Could you just discuss a little bit about that?
Yeah, absolutely. And I went back to the mediation treatise to get some statistics to share. And I do think that even though the Uniform Mediation Act hasn't been maybe as widely adopted as some other uniform acts, the influence of the UMA has clearly been felt in the amount of litigation that we see coming from states that have adopted the Uniform Mediation Act. And even in states that didn't, the courts trying to sort of struggle with whether something ought to be protected, a mediation communication should be protected, look to the UMA. And we're always very proud when the treatise is cited because it is sort of discusses how all the states are managing with confidentiality issues. But I thought what was really interesting, and I hadn't remembered specifically, was the number of cases when mediation became popular in the cases related to enforceability in particular dramatically increased. But after the UMA's adoption, they started decreasing in the states generally, but specifically in the states that adopted the UMA, while they went up in the federal courts. And in 2017, there were 600 federal cases involving mediation. Now that runs a gamut of issues, but many of them focus on whether the parties have to go to mediation or whether the mediated agreement is enforceable. But 600 federal, but only 291 state cases. I think I had some other statistics on that I was going to talk about. Here it is. During the first decade after approval, which at that time was in 10 states plus DC, there were fewer than 50 federal and state cases published on Westlaw discussing any aspect of the UMA. We had a similar result in the second decade of the UMA, with 43 times federal or state courts interpreted the UMA to resolve a dispute about confidentiality, where 7% of the total number of cases addressed confidentiality at all. And then what we did, so in other words, the number of cases in states or federal courts in states where the UMA had been adopted saw many fewer cases challenging questions about enforceability or confidentiality. And so it's hard to say it's just the UMA, because we could also be thinking that this generation and really a couple generations now of lawyers have grown up with mediation. Our generation had to learn about mediation. Now it's sort of integrated into the curricula. And so it may be more acceptable, or lawyers understand better what the purpose of mediation is, and judges understand that they shouldn't be looking at mediation communications. So that could contribute perhaps as much as the adoption of the UMA, but maybe adoption of the UMA sort of normalizes the idea of, and it's promoted within the state, normalizes the idea that this is a confidential or privileged process, and we shouldn't be attempting to append our communications from mediation on some document challenging the enforceability of a mediated settlement agreement, which I remember when I first started looking at the cases, and judges would say, yeah, I'd like to hear what happened in that mediation. And the lawyer would say, no problem, let me tell you about it. And nobody would bat an eye, even though all those states had some form of confidentiality statute applicable. So I think that the UMA, it's hard to, it's figuring out what caused what, hard to say, but I think it could only have helped in reducing the amount of litigation related to the uniform, or related to confidentiality issues. And I wanted to point out to California, and I wondered what you saw in terms of legislative history there, Michael, because they were very reluctant to embrace the UMA and chose instead to render incapable of testifying the mediators who participated in mediation communications. And most people studying mediation have read the Olin case from the Northern District of California, where the federal court really struggled with the fact that California had indicated in their evidentiary rule that witness, or the mediator, could not be a witness, was incompetent to be a witness in court, and ultimately concluded that, well, we could take their testimony in camera and balance the interests of justice and decide whether or not to allow those communications in. And even after all the struggles that California's had with their absolute prohibition on mediator testimony, instead of abandoning it and maybe considering the UMA, they instead decided to adopt a disclosure requirement where attorneys now disclose in writing that mediation communications are confidential, even if they constitute malpractice. And I don't know, I'm curious what you have to say about that, Michael, because I don't know what the debate was there, that they've now struggled with this question for so long, and yet had they just adopted an exception in the first place on attorney malpractice issues, that would have been an issue that was dealt with. And I think I moved from mediator incompetency as witnesses to that issue, but just thinking about both of those as sort of problematic aspects of the California evidence code related to mediation.
Yes, you slightly touched on this, but for the states that haven't adopted the UMA, what does litigation look like connected there?
It depends. One of the things we're seeing so much of is the inclusion of mediation in parties' agreements. And a lot of times parties aren't doing a very good job of writing their agreements to mediate. Sometimes they agree to mediate, followed by arbitration. Then they agree to negotiate, then mediate, then arbitrate, and they put ridiculous time limitations on themselves. So they can't possibly accomplish it. And then one of the parties goes to court and says they didn't mediate. Then the courts, what I've seen a lot of in terms of case law, and this isn't so much related to the UMA, is just a lot of litigation over what to do about the fact that a party didn't participate in mediation, which is not really something the UMA addressed. And maybe it's something that down the road ought to be addressed more uniformly, because courts really struggle with what do we do about this. I would say we don't see as many attempts to bring mediator communications in, or mediation communications into proceedings. And I think that's really because of the UMA and perhaps the amendment to other state statutes related to confidentiality, even if they didn't adopt the UMA. That's not one where we're seeing a lot of cases, which is probably a good thing. I think we're seeing them more around enforceability, which is always a problem, and whether parties have honored their agreements to mediate.
Well, thank you so much for sharing that. I think we're going to move our conversation forward for Professor Moffitt, and then we'll more of a group discussion. But when we talked on Monday, you briefly mentioned that you had some previously maybe grouchy thoughts about the UMA. So how is your
grouchy?
how is
Start
your
grouchy.
how is your perspective on the UMA evolved over time?
Let me cool to be here with you guys. Let me start by giving the sympathetic voice to my grouchiness, and that is when I understood the scope of the initiative of the UMA, I was super excited because I thought that part of the effect of having Uniform Act work would be legitimizing. It would be something that would lend importance to this field to which I was devoting my professional life. And so I think I thought this is gonna make it legitimate. I don't know what I meant by legitimacy in my head, but in my mind, it would super help. And then I quickly came to understand it, and this is an oversimplification, but at the time, I came to understand it really to be about confidentiality. And I didn't have particular opinions about confidentiality. I could invent them. I could see the policy trade-offs between, but they didn't motivate a lot of my thinking. And so I thought, well, this is underwhelming. There are so many things that one could do. Really? We're arguing about the scope of a privilege and its exceptions, and that was part of my grouchiness beyond just baseline grouchiness. I also had just some questions that I was wrestling with. I get two in particular. One, I continued at that point, and frankly still continue, to wrestle with the foundational premise as a policy matter that we need confidentiality in the ways that people assert that we need it, or contest the idea that we need it. I don't know whether we need it or not. And I had not yet evolved to Ellen's entirely persuasive perspective that what we need is predictability. Wholly aside from what the answer is, we'd like to not fight about the question. And I had not gotten there yet. I hadn't caught up with that yet. And then the other piece, just because it's about my grouchiness, it can be self-centered. The other piece of it was I only had really robust experience with mediation in a few contexts at that point in my career. And they were contexts in which, again, confidentiality was not the central animating question. I had spent zillions of hours in small claims courts and related, and there are confidentiality questions there, but I'm not sure that this really gets at some of what happens on the ground in a small claims court. I had at that point public sector labor bargaining, which raises some really fun open meetings, open records, questions that you kind of need a carve out for, or else, but it wasn't the core. And I'd spent a lot of time doing international public disputes where it was not in the shadow of a particular piece of litigation such that one would imagine a privilege. This is linked to policymaking prospects and implementation and enforcement and a lot of things that it are contexts in which the notion of a privilege about who said what in the development of is just not relevant. And so the grouchiness was not it was mere grouchiness. It was not animus. I just didn't care enough to spend my energies there. Again, for those for those reasons. How has it evolved? I've got more experience now seeing places where it is squarely in the crosshairs of where the fights are. I don't think we have resolved the question empirically, experimentally, or otherwise about what effects this or that level of confidentiality have. I know what makes me most comfortable when I'm mediating, but that's not really the policy question. I do quite like Nancy's point that even beyond uniformity, the notion that it is law improvement to spend this much time churning, there is something to the crucible of drafting and then having lots of people look at a draft and make fun of it and drafting again. And that's unpleasant as it may be. I think that does improve things. And then I guess the last thing I would say is just as I tried to think about how was I going to feel about the Uniform Mediation Act after its adoption? How would I measure success? I could only come up with three things. I mean, you could say it's successful based on how many states adopt it, right? That is certainly one of the kinds of ways that people, right? Uniformity becomes the goal in and of itself. And on that metric, it's been fine. Well, I was surprised to learn the number of uniform acts that have been adopted by 0 states. There's a good number of them. And I think, well, whatever else one thinks about whether that was a success, that's a hard argument to make. But the fact that California didn't adopt it, okay, California, what are you going to do? I can say that I'm from Oregon. In fact, I think I'm required to say that. Adoption would be one criterion. A second criterion would be the extent to which we're seeing derivative litigation about it. Because if it's well drafted, we shouldn't see much. And there isn't, right? So on that metric, I think, man, good on you for drafting. That doesn't answer whether it accomplished good policy goals, but it sure didn't create a lot of transaction costs related to ambiguity in the drafting. And so on that metric, it seems like it's done great. And then the third sort of squishiest of them is, did it accomplish any other policy goals beyond those that are inherent in uniformity? Did it create, whether reference to my 4 or the rejected 4, did it create, in fact, let's start with the rejected 4, did it create more fairness, more justice, more access, more, I don't know. I don't know. I'm not sure that it set out to do it, but then I circle back on myself to say, but gosh, there's so much more work to be done. And maybe it's not the Uniform Mediation Act's work to be done. I take the point about maybe it's model laws to be done, but there is so much more to be done to realize the potential in mediation. And so I think I am less grouchy either by nature or because my grouchiness has moved on to other things or what, I'm not sure. But I think there's much in the Uniform Mediation Act that has withstood the test of time on metrics that one would predict at the beginning. I think there's a lot to be proud of there.
Professor Moffitt, you mentioned that you hoped to be excited about the UMA when it was initially put together. And I want to point out there was a symposium series at Marquette in 2001. Ellen, I think you had a short article published there. I think it was the precursor to the argument you just made on uniformity. One of the individuals who wrote there was a gentleman named Scott Hughes, who I think was involved as a critic of the process. And he first of all, fun reframe. He reframes privilege as keeping secrets and avoiding testimony. Okay, and I like that fun reframe as the negative side of what privilege is doing in the UMA. But he quickly evaluated the reporter's notes, right, and coded for some words. And he found the word confidentiality or its derivatives 25 times. And he expresses disappointment in this article that impartiality and self-determination are way down the ladder, 5 times each in the reporter's notes. Obviously, you've discussed here that the ULC was pretty clear. If it's not about confidentiality, it's not in here. But Michael, to your point, what would have excited you about the UMA? Is it self-determination? Is it empowering party empowerment? Is it justice, as you just mentioned, what would have gotten you excited had it been at UMA?
Maybe it was even more self-interested than that. I couldn't find any scholarly niche into which I could try to get.
I don't know.
I don't know. I think probably I would have been a bad choice to be part of the UNA drafting process, but on reflection, I think my colleagues are right that where a lot of the friction still exists, friction in the transaction cost sense, where the problem still exists, where we are spending public and private resources on fights that are the wrong fights, are around things like, what do we make of this crappy agreement to mediate that somebody at the last second put in a contract? What do we do with that? I don't think a Uniform Mediation Act could cure that, and that may be more like model language. And maybe we're seeing more of that being cured in the arbitration sphere because administrator groups have their own model. There's a financial incentive and. But I do think there remains in 2026 a lot of good work that some student should do to help make it easier to create defaults. I love that mediation can be bespoke, and I will fight on that hill as long as there is a hill, that we need to preserve that part of autonomy. If people want to construct a mediation process that looks weird to me, they should be able to do that. But I think what we're getting is a lot of sloppiness, not intentional design choices. And that's an area where I think, honestly, we could benefit, we collectively, from some drop-down menus, from some choices. I think there are ways in which we aren't yet realizing as much benefit from defaults and nudges. Yeah.
Well, and I just want to pause and note to the folks who are online and the folks in the room, we're going to transition to questions shortly. But really, I want to open it up for the group to discuss. And I saw both Ellen and Sarah wanted to jump in. So,
I remember, I think I learned this from Nancy, as I've learned many things, that it's good to ask lawyers why they do what they do. And so a question I've often asked lawyers is why don't you tailor your arbitration agreement or your agreement to mediate more effectively? Why do you, to the extent you do, just use whatever AAA or JAMS has said is a good arbitration clause? How long this contract's going to last, and we just don't spend time on the dispute resolution provision. And I guess I kind of accept that, but I've also now seen these sort of creatively drafted agreements that I wonder if a lawyer,
mischief.
they're actually in some ways worse. They just create this increase in litigation about what has been agreed to, and put courts in a tough position to figure out what to do. And usually it's to voluntarily dismiss the case and let them refile after they've tried to mediate, which at that point probably isn't going to be very fruitful because
more intuitive and more like the attorney-client privilege in lots of ways that it works, so lawyers would understand it. It could be explained in words that lay people could understand, and ultimately would positively influence, would reach the point at which people had reasonable expectations and those would be met in the process about confidentiality. So I think it's a really tough question, and I'm afraid that we as lawyers don't often ask the question that you asked. What is it that makes a law effective? And it clearly takes more than good drafting. It takes a strategy. And I'm not sure we've had that yet.
We did in Ohio have the benefit of the Supreme Court office taking the lead on setting up trainings and explanations. I mean, there was a whole program because Ohio was one of the first adopters. And clearly that's not enough, and it wasn't aimed at the public, but it was more than most states did in terms of, we've got something we have a transition here. Let's get, people to understand where this comes from. I remember being impressed with their trainings that they did. Yeah, but yes, but it certainly doesn't get to the public, and it didn't get to lawyers in general.
And I guess I wonder how many of your classmates graduate without being aware there's a mediation process, much less, a privilege associated with the communications they probably went on.
This law school.
Yeah, even if it's law school, like, hopefully they do it. It just doesn't encounter it, but then in practice does. But I do also wonder, just the sort of side note of, we often talk in the academy about the demise of the joint session, and I know that some of our colleagues through the dispute resolution field have studied it, and joint session is only dead in some areas of the country and not others. But to what extent are things like the UMA important if we don't have joint session mediation? Because then it's really more the matter of the mediator having the conversation with the party, and the mediator is not going to reveal anything from that conversation. So does that mean we don't need the UMA? Maybe I throw that out. That's a question. Need it as much?
Well, I think it does. I mean, there are certain areas that don't need it as much. As Michael started out with, all claims court, you rarely hear anybody, they're going to glaze over if you tell them about mediation and confidentiality, and there rarely are any problems. So I think there are areas needed in much laws is like that. Only there for when it's needed, hopefully.
And even when the mediator is just the go-between between two separate rooms, you get this noisy translation. I mean, the mediator is spilling things. And even if the court case would be the mediator said, then the mediator invokes their privilege. So it seems to me that you don't have as much direct confrontation without joint sessions, but you could still have confidentiality issues.
I'm also hoping that there is a student out there who's going to write the article about the mediator who is artificial intelligence, and how all of that needs to be rethinking.
Well, and as to that point, Bill and I were talking with Michael about this last night, but there's one of the mediators I've been working with is now said one of the things that is not well known is what is the process of negotiation during a mediation among the parties. And they are now keeping records of, as mediators, they're keeping records of what's happening in their mediations, how the offers are going back and forth, and trying to log or keep record of what kinds of disputes they're mediating, so that they can feed that into a closed system AI that they have faith in, to help mediators understand the patterns of negotiation more effectively for certain types of cases, to, provide the AI assistance to the mediator going forward, where you could say, well, in a case like this, if you make X offer, you're almost certainly going to hear Y response, and then Z, and then, and then we're going to end up here. And whether that's going to be helpful to resolution or make parties more, entrench them more, I don't know.
I propose being grouchy about that.
Yeah, exactly. Great. I was thinking about her.
Yeah.
Grouchy code for something else.
Well, I do have concerns. I have a couple of concerns about that, beyond just technophobia, which I don't think I have, one of which is skepticism about whether it's closed and what sorts of privilege waivers one might be engaging in to permit the collection and analysis of these data. But more importantly, I worry about whether it becomes self-reinforcing. That is, the predictive becomes accurate precisely because the prediction is made. And I have yet to be reassured that I should not have that concern, and yet we march onward.
Other questions from the audience or online? Go ahead.
It has been kind of a recurring theme throughout the day that uniformity is good, because everything that is uniform is therefore by definition good. What happens if you have uniformity as to something involving the UMA that is not that good. Maybe technology has taken over and changed the circumstance. Maybe a leading court has a precedent that interprets the UMA in a fashion that's not terribly advantageous. What's the mechanism other than just amendments whereby we as a legal profession and as a society can make sure that uniformity always means an improved, good uniformity rather than uniformity of something that's less than ideal? Is amendment the only thing we can do, or are there other ways we can make sure that everything is uniformly as best as we can make it?
Well, one answer is, it's the usual democracy answer, I think, Harold, which is you should participate as it's being made. People who did actually change the course of the drafting process. But as you say, some things are learned afterwards. And the one thing that uniformity or Uniform Act doesn't prohibit is for a particular state to change theirs. They can do so. They're not tied to forever using the Uniform Act. And perhaps if enough states do that, the Uniform Commission may come back together and say maybe we should publish and suggest it to other states. So the Uniform Commercial Code, I think, is a good example of how that can grow over time and how amendments can occur, be studied, be recommended to other states. So I think it is an amendment process. If a court has an interpretation that leads to mischief, it's an amendment process or an appeal from that court. But I do think that it underlines the need to participate.
Another possibility is that if it is a problem that you spot only after the fact, that's one sort of thing. And then maybe you have to go and if it's a problem drafted in a way that would prohibit disputants from engaging in a bespoke adaptation. If I am someone who anticipates that in this context, the default rules that are set serve us poorly, then I can contract around a lot of that.
Do you see, what do you see in terms of do you see further development of the law? And I guess, are we ready for certain areas? Are there certain areas we need, be it a Uniform Act or model laws or standard clauses or whatever would be appropriate? Are we ready for something on enforcement? Are we, where do you think we are in the arc?
I think we don't need much more law. I mean, their change makes us look at existing law, but I don't have a sense gee, I wish I could persuade people to be open process and look at more law. I more wish that as these laws keep being enacted, that the people enacting them were asking, is this really necessary? How would this new duty we're imposing affect? Could it be enforced at all with confidentiality, or do we want yet another exception to enforce this new duty? Would people learn about it? Is there at least a chance that it wouldn't catch people unaware more often than it would do some good? And is there some other way to accomplish this goal? I more feel like there's too much law. What do you think?
I think I'm inclined to agree with you. I have seen now in the international area this push for confidence about enforcement, but it's not driven by enforcement per se and having a method for it. It's driven by let's get our counterparties in some other country where they're not used to mediation. Let's get them feeling comfortable that it'll be enforced so that they'll agree to mediate with us, which is a very different motivation than setting up a privilege that's going to be invoked in court. On the other hand, I hear Sarah saying that enforcement's a huge subject for litigation in this country, and maybe we could use something on enforcement.
And I always say with respect to that, even though we do see more cases both on agreements to mediate and on enforceability of mediate settlement agreements, it's probably such a small number in the vast scheme of cases that are mediated or resolved through mediation. That's sort of a question we don't know the answer to, is how many cases are mediated in the United States each year, and we see such a small number of disputes arising out of them.
Maybe what we need is not more law, but more research.
Right.
Because we could do that too.
Full deployment policy.
Yes, of course.
Other questions from the group as I'm attempting to keep recording? Yeah, Joanna.
My question with the uniformity, and you touched on it in a few different ways, but how do you see uniformity across states intersecting with uniformity across practice areas? You mentioned mediation in a family law setting. Is it more important that it's uniform in family law, or is so how do you make sure that family law mediation in Ohio is the same as family law mediation in California against area versus states?
That's such a good question. And I think, although I'd like Nancy to correct me if I'm wrong, that one of the reasons we looked at confidentiality was in the treatise, we had state statutes on confidentiality in every state that were generic mediation statutes largely. But then we also had to embed in different subject matter areas. I'll let you take it from there.
Yes, and then there were privileged deserts. It was the laws, I think, originally were written while somebody was concerned about starting a new program in family, and while the pen was out, they said something about how the information would be used, and so it varied by practice. I think one of the questions that you have within a state, which is such a good question, is if you're trying to keep the transaction costs low, the lawyered cases. Do you want people to pay for a lawyer to have to check every time they are involved in a mediation, which of the laws in the state applies, and then what other states could it come up in, or what federal court, and what are those laws, and then come up with some way to advise you. You'd like to reduce that if you could. And that was one of the challenges. Could we draft a mediation privilege law and have people on the drafting committee and commenting from all those different contexts say, it would work if you did X, and include it. And could we include that? And would that not cause a problem in the commercial area to get tax in there in the family area? And what about neglect of children and the use there? And so I think that is, you're always weighing. If you have individually drafted statements for each context, it will fit the context probably, although some of them just aren't that well thought out. But if you can draft something that fits across contexts, then that is some savings to people in terms of the cost of using mediation, and particularly if they're lawyered.
That's why one of the reasons mediator certification failed, because different areas felt they had different needs and different ability to pay and different interest in it. And so now we see we talked in class about some organizations providing special fees, but that generally speaking, there's no understanding of, or no initiative now to develop any sort of national mediator certification because people didn't agree and they were more agreeable with respect to confidentiality and privilege.
Yeah, I think so. When they became involved and really wanted to see each other succeed, there is that generous spirit, if you've noticed it in mediation. We're not trying to hurt family mediation, even though we don't do it. You know, we would like to be supportive. But I would say that one of the things that this process permitted, it was a 5-year process, you know, so, and meeting every few months with a whole new draft and sending it out to national organizations that represented all these different groups. Rarely, when somebody's setting up a program, do they have the time to do that kind of a process. And rarely, if you do it state by state, would you see it happening. So in some ways, it's kind of a privilege to try to say, can we simplify the law for at least some of the states? Can we put our lawyer mind to work to try to make mediation work better in that one way?
Lots of questions. Maybe one more, and then we'll close things up. Does that sound good, Ryan?
When Professor Froehlich goes to get his haircut, the barber will have to have a license to do it. So is the fact that mediation has the backdrop of litigation behind it, so mediators can't do harm, does that excuse still hold?
Disclosure, Ryan wrote his paper on certification of mediators, so he's a little bit more knowledgeable about that. It's such a struggle. I wish there were a way of doing certification without having it cost money, because I think that was a big obstacle for mediators. They were struggling to see how they could afford it. Many of them don't make lots of money, for mediators aside. And then trying to figure out what those standards ought to be. And one of the things that I learned in working on the treatise was that even though we think education and training matter a lot in mediation, that at least from the surveys of participants in mediation, the thing that seemed the most important thing was experience. And, experiences, there'd have to be some sort of mentoring, as they do down in Florida, where you apprentice to a mediator. And that's such an expensive model for training mediators that it's probably not very realistic in most places. And so sort of long way of saying there didn't seem to be the desire to continue with the mediator certification. And I guess we could say, and you study this, there's not a lot of lawsuits against mediators either, which doesn't mean there aren't mediators doing bad mediation, but at least it's some evidence of that. Michael, this is something that
I got tenure by pointing out 2 things. 1, mediators are human. 2, humans screw up sometimes. I got tenure for that with a lot of footnotes. Like that was, and it remains true that it is very hard to sue mediators for harms they cause in mediations for a bunch of reasons that we can talk about if you want. But it's not clear to me that the certification things we discuss would cure for that kind of harming. And so we have this awkward posture as a field where we neither have the barriers to entry to market that are aimed at quality enhancement, nor the after the fact mechanisms for punishing people and providing compensation for victims. We have neither of those, and most fields have one or the other. Some have both. Lawyers, you need to pass the bar, you need to do the ethics, and you can get sued. But most practices, barbering included, at least have the front end in a robust and meaningful way. But I think it's actually very hard for the state, aside from things like a court-affiliated mediation program and appellate, it's very hard for the state to declare a monopoly on mediating such that it could draw a regulatory boundary around it. There is no such thing as the unauthorized asking of open-ended questions. And so if the state of Ohio were to adopt something that says you need to have this kind of certification or licensure in order to be a mediator,
nothing would prevent somebody from printing up a business card that says, I'm a facilitator, or I'm a life coach, or I don't know, whatever it is that you are. The only thing the state would be able realistically to withhold would be the prospect of the benefit of something like a privilege, because it could potentially make the privilege contingent on satisfying, but the private market seems uninterested in that.
And Massachusetts did do that. I think while you were a student there, they had a statute that said if you didn't have X amount of training, you could not do your mediation wouldn't be privileged. But then who would suffer from that?
Right.
You know, the parties who didn't foresee that problem.
Wonderful. Well, I thought we might just take 30 seconds or a minute from each of our panelists, and then Priya and I will thank everyone. Perhaps we might start with Sarah and Ellen, and then Michael and Nancy. Does that sound good?
Well, first of all, Bill, thanks for bringing us together to talk about the Uniform Mediation Act, and it gave me a chance to ask Nancy some burning questions I've had about things I remember. And I, even if it didn't inspire everybody, for me, it really helped me, and I hope it helps students learn so much more about the underlying policies for confidentiality in mediation. And I think it's both helpful to litigants out there and hopefully parties as well, but also students, because it inspires discussion. It helps. The notes, I think, are a tremendous learning tool. And I think one of the favorite mediation paper topics is often, what should we be looking at next, as you mentioned, Bill, after? Should we have other uniform acts, or should we be changing these provisions? And I think that it allows for a way of discussing mediator privilege mediation communications privilege in ways that we didn't before. And I think it helps the courts and provides them guidance when they encounter these problems, which fortunately is not too frequently.
Ellen?
I'd also like to say thank you to both Priya and Bill. And I was struck when you described the UMA is not opening up paths of scholarship for you. It did for me, and in a large part through Nancy's influence of getting me involved. I mean, I didn't have an offer. I wasn't coming here. I was working at the University of Illinois, and Nancy got me involved first in the UMA, and I haven't stayed stuck on confidentiality, but it certainly it got me promoted, let's put it that way. And it's been a long and interesting trip, let's put it that way. And so I'm grateful for the UMA for that reason, but also to Nancy's mentoring and getting me involved. So.
Michael?
It was a Rogers and McEwen book that got me into mediation long ago, before notions of the UMA or anything like that. And so what a privilege to be here. Thank you for the invitation. The more I have practiced, the more I go back and see in the UMA that I did not see in my early readings of it. The text has not changed. I have changed. And that, I think, is true of many great works of art. It is true of significant religious texts. It is true of the Constitution. You sort of look at it and you think, oh, they thought about that? Now, I have no idea if they thought about it or if it just... But there is a lot that I now see in it with the benefit of having a lot more and varied experience that at the time I didn't appreciate. I would not have been able to reverse engineer all that was going on in the drafting of those words, and now I see it as such an elegantly, sort of tightly drafted piece
of work. I am stunned that that many people had a pen, and yet it is as short as it is. That is, I think, extraordinary work, wholly aside from the wisdom baked in it. Thanks for letting me be here for this.
And Nancy?
Well, I'm reminded, I always think of history as something that's just background. Those of you who are active now can build on it in ways that make sense now. So the history, it's a delight to be a part of reliving that. But I also would wish for you what I now, on reflection, realize I value actually the most about this process, which is the chance to interact with people you admire and care about over time, who have generous spirits, who have the goal of really contributing and solving problems and keeping themselves as open as possible and as defensive as little as they humanly can. And what it will give to you, I think, in terms of a lifetime is many valued friends and many great memories. And certainly I had that. I had the luck of being here at this law school, where if there was a cause that was worthy to me, I would either be told it wasn't worthy in kind ways, or I might get some people to jump in with me. The really good experience of being in the mediation field itself, where I believe that people have a generous spirit in general and an attitude that allows them to want to contribute and to improve the field. They care about the field and they care about the people involved. So I say to you as young people, try to pick those causes, the ones you can do with great friends that matter some, and seem like a good experience in that way, but also to do it in ways that are personally as well as professionally fulfilling.
Priya, any last comments, or do you want to take us out and say
Yeah.
goodbye to everyone?
I mean, I'm always quite amazed by the opportunities I have at this school, specifically in the dispute resolution program. It's not every day where you go from reading text on Monday to then getting to sit with people who are drafting the language a couple of days later. So I'm really grateful to have been able to sit in on this conversation with you all. Specifically to Professor Froehlich for inviting me here today. It reminds me how much I have to learn, but it also excites me just in general about what's out there in this field. So thank you all so much. And should I just end? I mean, thank you all for being here today in person, and thank you.